Welcome to the Florida Divorce Podcast, your source for the information you need to successfully get through your divorce and into the next exciting chapter of life. Now, here's your host, Attorney Scott Kalish.
Hey everyone, this is Scott Kalish. I am a divorce and family lawyer in South Florida. Today I want to talk to you guys about, divorce and children, and I specifically want to talk to you guys about the 5 lesser known facts or aspects of this area of divorce law. Before I get into it, I want to just let you guys know, give you guys a quick little update on my firm. We're actually up to 3 attorneys now, including myself. So we just added another attorney this past week. So right after the new year, we're super excited about it. Her name is Serena Collins. She has a ton of family law experience. So that's definitely going to allow us to keep taking on more cases. Our hope is to expand beyond what we are right now. Right now, we're primarily practicing on the East Coast of Florida. I would say from Miami to Vero. But now with Serena, I think we'll be able to begin to take on cases on the West Coast and possibly even Central Florida. So if you're there, don't hesitate to reach out to me. Adding another attorney definitely allows us to begin to scale and to begin to add cases throughout Florida. So enough about the firm. Let me kind of get to the material. So I want to talk to you guys today about divorce and children, and I want to talk to you guys about 5 aspects of this area of divorce law that people, don't necessarily know. Sometimes people have a misconception just based on word of mouth and just talking to people that may know something about divorce law in Florida, but they might not know, exactly what they're talking about, right? So there's a bonus, right? The bonus, I know I said 5, but the bonus is that we don't actually use the word child custody or the term child custody anymore. We use the terms time sharing and then parental responsibility when we're referring to what was known as custody, right? So just so you know, if you're new to this area of the law, right? So we, time sharing is the word that's used in court. And we also refer to parental responsibility when we're talking about decision making and minor children, right? So let's get into it. So number 1, so this is something that is a little bit controversial, right? I know the legislature in the past had attempted to change this, but the first one is that 50-50 time sharing, right? So 50-50 custody is technically not presumed, right? So it doesn't, the legislature and the way that the law is right now in 2023 is that when you're going through a divorce and you have children or a paternity case, right? And there's obviously going to be a child involved in a paternity case. When you're determining what time sharing schedule is in the best interest of the child or children, we don't automatically say, hey, it's going to be 50-50 unless, otherwise shown, right? So 50-50 equal time sharing is technically not presumed. We, as lawyers, as family lawyers and judges, right, the family judges, we're supposed to take a look at what's in the best interest of the child or children and weigh the over a dozen factors, that's included in the statute, right, when coming to that answer. So really quick, right, so again, just to summarize, 50-50 is not presumed. We don't automatically say, hey, 50-50 unless otherwise proven. Again, they were trying to change that law last year. They were not successful. Ron DeSantis, our governor, he did not sign that law or that bill into law. So, we don't have that on the books yet. That might change, but as of right now, we just don't have that. All right. So the second aspect of children and divorce law that's lesser known is that the mother or the wife is not automatically favored to have more time, right? So in the law, both parents start on an equal playing field. And, neither parent has an upper hand, right? Both parents are obviously, presumed to be good parents. And we start from there rather than, hey, historically mom, or just because mom is a female, just because mom is mom, we're not just going to automatically favor her to have more time with the child or children. Now, it may be that the facts, right, are that mom is the better parent, right? Mom is the closer parent. Mom, has historically been there, and there's a ton of reasons to give mom more time. I'm not saying that mom will not just get more time in general. I'm just saying that just the fact that mom is a female, that doesn't automatically make it to where she's going to be entitled to more time with the child or children. The court's going to look at the facts rather than just presume a certain schedule is appropriate just based on, gender, right? So that's something that is sort of a misconception. There's a myth out there that, dads always get less time just because they're dads. Maybe there was a time right before my time as a lawyer that was true, but in 2023 and for quite some time now, that is no longer the case. All right. So let's jump into the third one. And I want to talk to you guys a little bit about what a guardian ad litem is. And I want to first, just so you guys know, a guardian ad litem is not automatically appointed in every case, right? So in other states, guardian ad litems may be automatically, appointed when there are children involved in a divorce, when there are minor children involved in a divorce. But here in Florida, guardian ad litems are not automatically appointed. So really quickly, what a guardian ad litem is basically a guardian ad litem. It's a statutory sort of position, right, that the legislature came up with. And it's basically a person that can do a couple of different things, right? So they're appointed by the judge, and it's an independent person. Sometimes it's a lawyer, sometimes it's not, but it's basically a person that can come into the case and act as what's called next friend of the child, right? They can see what's going on and then recommend to the judge what time sharing is appropriate, right? Or they can come into the case and investigate, a certain claim, or maybe evaluate the situation, or maybe evaluate what one parent is saying, whether or not that it's accurate or not. Maybe one parent is saying that the other parent is extremely dangerous because of X, Y, and Z. A guardian ad litem can be appointed by the judge, and they can come in and investigate and evaluate the situation and determine whether or not that claim is legitimate, right? So that's just a little bit about what a guardian ad litem can do. I can do probably a whole podcast episode just on guardian ad litems, but just so you guys know, sometimes that's a misconception. People think that, when they start a divorce case and there's minor children involved, that a guardian ad litem is automatically going to be appointed. And that's just not the case. So they have to be appointed by the judge, and they're appointed when the court finds that it's in the best interest of the child. Now, either parent can ask for the guardian ad litem, or if a situation is a certain way, a judge can just appoint the guardian ad litem sua sponte, they call it, right? So that's just on their own. The judge can just on their own determine that a guardian ad litem is appropriate and appoint one. All right. So let's get to number 4. This is another, sort of misconception, something that not many people know, or a lot of people have a question about, right? So when we're talking about a time sharing schedule, a lot of people want to know if there's like a certain age that a child could automatically just choose who they want to be with. And the answer is no. Up until the kids are 18, the judge has the last call, right? So a child's preference on which parent they want to spend more time with is only a factor, and it's not weighed heavier than any other factor that's in our statute that basically are analyzed, right, by the judge to determine what's in the best interest of the child or children, right? So a child's preference is just one factor among many different factors, right? So depending upon the situation, a judge can consider that factor, and maybe now if the child is old enough, a child's preference can come into play. Now, I want to read the statute to you so you can, get a sense for what it says, right? It says, the reasonable preference of the child if the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference, right? So there, the main thing I wanted to bring up for this, just for this podcast episode is that the child's preference is just one factor among many. And a child doesn't necessarily get to choose and have the ultimate say at any age, right? So that's sort of a misconception. People think that, or sometimes they come to me and ask me, well, at what age can the child just pick? And there's not really an age, right? There is no black and white answer to that. The answer really is never, because a judge will always have the ultimate say. And a judge is pretty much going to, still go through the factors, all of the factors, and make a ruling based on the best interest of the child. Now, it might be that in your situation, if your child is older, right, in their latter, teenage years, that they have expressed a preference, and there are other factors to go along with that preference, and that one parent shouldn't get all of the time based upon, the entire situation. I'm not saying that that's always going to be the case, but that could be the case, right? So a child's preference is just one factor among many that a court has to take into consideration when making a ruling on what's in the best interest of the child or children. All right. So that's the fourth, I believe. Yep. That was the fourth. And the fifth is also an interesting misconception, right? So a lot of people come to me and they think that if one parent is not paying child support, that they can automatically deny the other parent time sharing, right? Time with the kids. And that's just not true. It actually says the opposite in the law, right? In our statute. The legislature made a point to include that and say, hey, even if one parent is not paying child support, that is not a reason by itself to deny the other parent time with the child or children. So even if one parent is not paying child support, they can still see the kids, right? So that's a big misconception that I get sometimes. People think that, hey, that's part of the law and it's not. So there you go. There you have it. 5 sort of misconceptions or 5 lesser known aspects of divorce and children, right? When children, are involved in divorce, these are 5 aspects where people know less about, or there's, some myths out there about these areas. So if you guys like this podcast, if you've enjoyed it, if you've gotten something out of it, please give it a 5-star review. If you guys have any questions, please let me know. You can email them to scott@kjlawfla.com. If you'd like to work with us, also email us, or you can call us at 561-208-1859. Again, 561-208-1859. Give us a call and you can speak with our intake specialist and we can determine whether or not we're a good fit for you and you're a good fit for us. But we'd love to work with you if we're a match. And yeah, thank you again for listening to the podcast. I really hope that you've gotten something out of it. So have a great day and look forward to the next one. Take care. Bye.
Thanks for listening to the Florida Divorce Podcast. To learn the 10 secrets behind every successful divorce, visit FloridaDivorcePodcast.com. If you'd like Scott's help in your divorce case, go to KJLawFLA.com.